Before we begin, Sir James, I would just like to draw everybody's attention to the fact that there is an anonymity order in relation to one of the parties to this case. In the usual terms, no one shall publish or reveal the name or address of the fifth respondent who is involved in these proceedings, or publish or reveal any information which would be likely to lead to the identification of the fifth respondent or of any member of his family in connection with these proceedings. I always start by drawing people's attention to this because although I'm sure none of the people before the court would make any slip in this respect, it has been known. And so precautions are necessary. After all, the proceedings are being transmitted live throughout the world. So with that introduction, Sir James.
My Lords, good morning. Just on housekeeping first, if I may, you've got a little black ring binder, I'm afraid, which has got three things in them. And, two of them are Strasbourg authorities, one of which I might refer to, one of which my learned friends might refer to. We'll come to that in due course. And the third of them is the explanatory memorandum to the 2017 regulations passed on the same day on which Al Chodor came out, which wasn't, I think, included in the original version. It's behind, the regulations themselves are behind tab 13 in bundle 2 of the authorities, and that would be the natural physical place to put it, if you wanted to extract it. I hope that's it. I'm also assuming I don't need to go through representation. You have the timetable, you have the hymn sheet.
Well, it's been drawn to my attention that although we know who is who, the rest of the world doesn't necessarily know who is who. And it may therefore be useful to repeat it. Just goes to show that when one introduces innovations that are intended to save time and trouble for everybody, there's always a downside.
Yes, so the anonymity order is only in relation to the fifth respondent.
Only for the fifth respondent, yes.
Yeah, so the representation before the court is that I appear on behalf of the Home Secretary, who is the appellant. I do so with Mr. Tam, who is absent until lunchtime. I think with the court's permission.
We knew about that, yes.
Mr. Payne and Ms. Anderson. The first respondent is represented by Mr. Michael Fordham, Queen's Counsel, and Raza Halim. Second respondent by Michael Fordham, Queen's Counsel, and David Chirico. The third and fourth respondents by Mr. Southey, Queen's Counsel, and Greg Killet. And the fifth respondent by Mr. Fordham and Miss Sabick.
Thank you.
Now, ladies, my lords, the facts of these cases, if I could invite you, I'm going to try and do as much as humanly possible by reference to the reported judgment or judgments in the Court of Appeal. If you go to MS page 246, you have the Court of Appeal's judgment in the first volume, the core volume. Core volume. Core volume, page 246, and the facts of the cases are set out in the judgment of Lord Justice Sales between paragraphs 16 and 43. Given that we're principally here concerned with issues of principle, I'm going to take those paragraphs as read, if I may. The procedural background, which is of some complexity, as you will have spotted, is also very helpfully and comprehensively set out in Lord Justice Sales's judgment, this time between paragraphs 44 and 81. For present purposes, it may also be worth reminding the court that at paragraphs 100 to 103 in the judgment, MS 279, there is a very helpful description of the range of circumstances in which detention, in our sort of context, might happen. So those 3 or 4 paragraphs helpfully summarize the various situations that might arise in relation to detention, and therefore the sort of situations that might or might not fall within a Dublin III detention as compared to other types of detention. So if I can recommend those paragraphs at the outset. The order in which I was going to take the submissions is this. I was going to address, first of all, incompatibility with EU law, and I was going to do that in two parts. The first, which broadly tracked the issues as they arose in the Court of Appeal and the issues as identified in the SFI for present purposes. The first part of that incompatibility issue is whether, in principle, the UK system qualifies as, quote, law, close quotes, or whether only legislation will do. And secondly, whether, if it is in principle possible to have a compatible EU law system which is not comprised in legislation, whether the content of the Secretary of State's guidance is sufficient. Then I was going to move to the damages issue. That obviously only arises on the premise that the system is not compatible. And I'm going to address that briefly in three short parts: EU law damages, domestic law damages, and nominal damages only, question mark. And then finally a short section at the end dealing with consequentials in relation to the individual cases. Helpful structure. I was going to turn directly to incompatibility. And the main submission, the main and first submission that we make, is that Chapter 55, which is the Secretary of State's policy, plus the framework of control by our domestic courts that surrounds that policy, can, in principle, be compatible with Article 28 of Dublin III, read together with the definitional provision in Article 2, subparagraph N. That was the Court of Appeal's issue 1A, as set out in para 115 of the Court of Appeal's judgment, and specifically it raises the question whether there is any requirement that law equals legislation. And under that main submission, I'm going to divide it into two parts, the first of which is to do with the principled approach to that question, and then I'm going to try and apply it to the circumstances that we have here. And I note immediately under principled approach that it is a very big issue indeed if law does mean and import legislation only, even in the context of detention. There would be very, very serious repercussions if that is required, particularly given the importance which a common law system such as ours attaches to case law and the build-up of jurisprudence in the courts. And the court will not be surprised to note at the outset that that Secretary of State policy in Chapter 55 and the relevant paragraph setting out the various questions to be asked is essentially founded on previous case law, effectively saying you need to think about these things, this thing and that other thing in the context of this sort of detention. But it has broader ramifications if that is truly a principle, even in the context of detention of EU law. We've referred in our case at paragraph 5.20 to some of those potential broader consequences if law can only mean legislation. In particular, we refer at paragraph 5.20 to potential ramifications in relation to the criminal context. And we also note that, as you're aware, a critical feature of the domestic control over detention in the immigration context is the range of principles laid down in Hardiel Singh. And that was held to be compatible with EU law, raising a really pretty serious oddity, or putting at risk that finding. It was held to be compatible with EU law, that set of principles, in a case called Nuazli. I don't invite you to turn it up, but the relevant paragraphs in Nuazli so finding are 75 to 77, and if you want it in the raw, it's in bundle 4 of the authorities behind tab 44. But my submission is that there is no reason in principle for any such requirement, that law can only mean legislation, for 5 key reasons. The first of them is that the EU law system, in this respect and in this context, follows ECHR jurisprudence and principles. And there is therefore no general principle of EU law that lawfulness and the legal rules that control executive discretion and thus protect against arbitrariness, the fundamental rationale for the in accordance with law provisions in the ECHR, can only be met by legislative provision. And we respectfully submit that it was the evident intention of the CJEU, for reasons I will come to very briefly in a moment, to apply ECHR principles corresponding to in accordance with law. Indeed, it might be thought that it would be very odd indeed if there was a fundamentally different approach under EU law to the approach that Strasbourg has always regarded as strict under Article 5 of the ECHR, but more generally when considering in the context of detention and indeed in other contexts what the principles of what principles underlie the headline principle that laws have to be in accordance with a concept of legality under that system. The fundamentals of the ECHR system you'll need no reminding about. They are that the controls are sufficiently foreseeable. There's got to be a basis in domestic law. They have to be accessible, neither of which are remotely controversial here, but they have to be sufficiently foreseeable, and they have to be capable of being legally enforced. And of course, as that Strasbourg case law makes absolutely clear, those requirements exist in order to control overbroad executive discretion through legal control. But the fulfillment of those aims, those basic purposes, does not import under the Strasbourg system any suggestion that you need a particular national legal form. This is about substantive compliance by the contracting states in that context with the principle of ECHR legality, which does not insist upon form. One can go all the way back to Sunday Times and the United Kingdom, which we've cited in our case at paragraph 5.27. And one of the authorities in your new little black file is a case called VM and the United Kingdom. Could I just invite you to take that up very briefly? And I do so simply because this is illustrative of the approach of the Strasbourg court in the context of immigration detention. That's probably all you need to know about the backdrop to it. But if you go to paragraph 58, first of all, you will see, and this is under the heading, as you see from the title above paragraph 52, relevant domestic law and practice. If you go to 58, you will see a recitation of precisely the guidance and policy that arises in this case. And you will see the reference to the risk that the person will abscond at paragraph 59. and then various other provisions specifically singled out in those paragraphs as relevant to the particular circumstance of that case. But they take into account, under relevant domestic law and practice, the very policy that we're considering here, between 58 and 63. And then at 82, if you go forward to the substantive argument, under Article 5, you will see the various general principles set out as governing the issues arising under Article 5, including lawfulness. Then if I can take you from there to the dispositive reasoning, or the reasoning which is particularly relevant to our case, between 90 and 92, you will see that they analyse the requirement in 90 in matters of deprivation of liberty for domestic law to define clearly the conditions of detention and that the law be foreseeable in its application. Reference to the quality of law requirements in Article 5.1f in 91. And they then decide that domestic law is in relevant part sufficient for that purpose, including reliance on the policy which you saw cited under relevant domestic law and practice earlier on. Now, the facts aren't exactly the same, but it's simply an example of the Strasbourg Court, in the context of immigration detention, relying upon the very policy which is of concern here. You're aware, as I say, that the courts have frequently considered Hardil Singh and all the others, and this policy itself. We've cited Munjaz also in the case that you will have seen. But we do respectfully submit that the Strasbourg Court plainly does not have any suggestion that in order to be in accordance with law, the relevant set of legal rules has to be set out in legislation. And of course the ECHR no doubt in part took that position, well recognising that the common law since Magna Carta has had powerful protections to ensure that any detention is properly controlled or authorised. And the policy is not some thing that has come out of the machine, as it were. It's a reflection of a series of important considerations that have become evident in the developed case law over the years. That's part and parcel of our domestic legal system. So we therefore submit that if the mere reference to law, and it's to that word in Article 2N of Dublin 3, as you'll recall, I don't, I think, need to take you back to Dublin 3 and show you the provisions unless you need them, but 2N, you'll recall, simply refers to law. If that mere reference to law in Article 2N meant something different to that which would satisfy ECHR law, then one would expect that to be very clearly reasoned and spelt out. And instead, and on the contrary, we submit that the ECHR analysis and principles underpin the entire analysis in Al-Chodor, the Luxembourg case, their entire analysis of Article 28. There is nothing in Al-Chodor altering those ECHR fundamentals. Can I invite you to take that up? It's in bundle 1 of the authorities behind tab 7. Electronics 1657 is the first page, if you're sure how many of you are on the screen. I don't know whether you will be. And the paragraphs I want for present purposes are 38 and 38 to 40, which are at 1687. And again, I'm assuming the court has had at least a brief chance to read Al Chodor before the hearing, but 38 to 40 for present purposes. See from those three paragraphs that they aren't just doing it secretly, as it were, they're positively relying upon and citing the ECHR approach. They're noting the direct correspondence between Article 6 of the Charter and Article 5 of the ECHR, and they are then relying upon the set of principles that were developed in all that detailed case law from the Strasbourg Court over the years. The fundamental rationale being the one set out in the middle of para 39, the protection of the individual arbitrariness, back to Lord Bingham and Gillen and all those cases. But that's the fundamental aim and object of the requirement that the that executive discretion be controlled by law. And then you see what that imports set out, and all of them are instantly recognisable from the Strasbourg case law in paragraph 40. So far from departing, or far from the CJU concluding that law in Article 2N imported something different, we respectfully submit that they're positively purporting to apply the Strasbourg case law and principles. And when they come to the more detailed consideration of those principles, all of the principles that they then rely on directly chime with and repeat essentially those principles that one finds in the ECHR case law. And again, you haven't got it in the bundle, but you'll recall that recently Lord Sumption gave a long judgment in the criminal convictions and cautions case of P, where he analysed all the various requirements under the Strasbourg jurisprudence of in accordance with law, essentially to this effect. So if you go, for example, to paragraph 42 in this judgment, you will see the reference to the fact and to the principle. Just picking it up in the second line, it's important that the individual discretion enjoyed, that is, the individual discretion to detain, read in conjunction with Article 2N, in relation to the existence of a risk of absconding, should be exercised within a framework of certain predetermined limits. And reading on, so the criteria should be defined clearly in a way that is binding and foreseeable in its application. And then in 43, there should be a provision of general application which sets out the limits of the flexibility in the assessment of the circumstances of each specific case in a manner that is binding and known in advance, and so protects against arbitrary deprivations of liberty by external direction of the discretion. But all of that,
Sir James, although we don't find the word binding in the definition, we do find the word binding here. And some of us may have thought, reading Mr. Fordham's case, that one of his stronger points might be that policy is not binding because it can be departed from for good reason. And are you coming on to that?
I'm coming very directly
because
to that, because I agree.
That is, that's quite a big point.
It is, and I'm going to come very directly to it for that reason.
I'm grateful.
It's interesting, there's a distinction, is there not, between the rules, the criteria. So in the case of immigration detention, you have got a very broad discretionary power in the Immigration Act. That is then, has been confined by the Hardyal Singh principles now for a very long time. Now, those were, of course, established by judicial decision, independently of the Secretary of State. The Secretary of State's policy is a means of giving effect to those rules. And then the courts have also said that unless there's a good reason to depart from the policy, it must be complied with. So in a case like VM, the rules, the substantive rules as to when somebody might be detained under the circumstances were actually the product of a combination of Act of Parliament and case law.
I mean, very broadly expressed, Act of Parliament, as my lady pointed
yes,
out.
indeed, but Act of Parliament and case law, they were not the product of the implementation policies of the very detainer. Might there not be a distinction between rules which are set out by Act of Parliament, statutory instrument, or the courts, and policies which are derived from the actual detainer?
My lady, that is the argument that I think is Lord Wilson's question redressed, if I'm allowed to say that.
Well, slightly so.
But
Yes.
my answer is going to be that policy does not exist in a vacuum. I don't want to get too far ahead of myself, but the policy does not exist in a vacuum. Policy of this kind is surrounded by the principles of public law, which are laid down by the courts and which operate to constrain any discretion. I leave entirely on one side for this purpose the fact that those questions, when we get to the policy, those questions are themselves the product of courts and a whole bunch of case law going back for hundreds of years, saying you need to think about this, that, and the other thing. They are a collation from the case law, but even if they came deus ex machina, as it were, they would still be surrounded by the important principles and controls that public law exerts. And when we get to it again, I will be submitting that those questions are really no more than a reflection of principles which have been laid down by the courts, such as legitimate expectation, consistent application of administrative practice and policy in an area as important as this, taking into account relevant considerations, and so on. So there are a whole series of, and the question will still remain, which I'm going to come to, which is whether or not the addition of the tailpiece policy can be departed from for good reason, whether in some way, shape or form that undermines their status as the sort of thing that my lady was putting.
But that wasn't what I was putting to you. I was putting to you...
Is there a distinction?
There is a distinction, and that explains the decision in VM, because the combination of the statute and Hardiel Singh produced principles and rules that were sufficiently foreseeable.
Lady,
the policy implemented those, and that meant that it wasn't going to be arbitrary.
Yes, but one needs to be a little careful with that, because Strasbourg did in VM rely, as part of domestic law and practice, on the very policy, a different part of it for obvious reasons,
yes,
on the very policy that we rely upon. And you'll be very well aware that in all sorts of contexts, Strasbourg has had regard to a whole series of things that are not necessarily either legislative or judicial authority. For example, in the recent Big Brother Watch case in the Strasbourg court about the interception powers, a whole panoply of different species of legal control existed, from primary legislation to parliamentary endorsed codes of practice, to guidance supported, as it were, by discipline and nothing more, that would guide the exercise of some of those powers within the agencies. So Strasbourg is prepared, as long as there is sufficient legal control and backup, Strasbourg is prepared to have regard to those things. And so in direct answer to my lady's question, we of course see that there is a distinction, but we respectfully submit that as long as the lesser beasts are sufficiently legal controls, it isn't to be regarded as a distinction, but a difference.
Can I just ask, just to remind myself, are the EIG rules purely a matter of departmental policy? They're not like the immigration rules having a parliamentary aspect.
I don't think they have a parliamentary stamp upon them, like the immigration rules, or like the code that I mentioned in the BBW case, which had the requirement for affirmative resolution, had to be laid before Parliament. So. those. I was trying to think back to whether what species one was dealing with in the case of Begal came to mind. Do you remember about stopping people on the border, and it was police stop and search? It was an aspect of that. And I know we had a debate around whether or not Section 6 of the Human Rights Act was itself a legal control for that purpose. But certainly there was guidance, and there were various, I think, police documents or Home Office documents which controlled the exercise of that discretion and were indeed dispositive. As I say, I'd have to check to see whether those were statutorily backed.
I mean, very sensibly, we've only been given chapter 55. It did cross my mind that no doubt somebody has looked at the introductory chapter just to see whether there's anything interesting said about the status of the
Sure
whole
they have,
thing.
but if not, they will. They certainly.
If somebody
will.
could just
If there's
look.
something- We certainly will. Anyway, the first submission is Luxembourg Court in Al Chodor purporting to apply Strasbourg principle. Second submission is that the context we submit is strongly against any requirement that it should be just legislation. The objective of the common European asylum system was, as you're well aware, to harmonise standards and approach amongst many different member states. And if you still have Bundle 1 to hand, you will see that reflected in the recitals to Dublin 3 at page 1249 in the electronic, behind tab 1 of Bundle 1, and I'm after recital 40 at the top of page 1249. So member states have a widely diverging set of systems of national law, including in relation to detention in the context of asylum. And the harmonisation process recognises that and is designed, we submit, to establish therefore minima, and it has done so, as you've seen from the history, by a gradual process split into different phases, the Dublin Convention, the Dublin II, Dublin III, with each phase involving years of negotiation, and on each occasion sets of minimum standards, but raising the bar, certainly in terms of safeguarding, but at an agreed pace, with the member states free to supplement and implement in the manner permitted by that developing process. And of course, immigration detention is and has always been a sensitive issue, where the UK did not opt in to the standardising measures, for example, in the recast reception directive, to which I'll come in a moment in Bundle 2 behind tab 20. But it would be very surprising indeed if into such a context, this reference in Article 2N to law introduced a change as fundamental as all forms of legal control except those set out in legislation are irrelevant. That would be a very, very big thing to be introducing, and a surprising thing to be introducing, having regard to that developing and minimal context. It would require a conclusion that Dublin III required a member state such as the United Kingdom, whose detention system has been consistently held to be lawful by the ECHR, fundamentally to change the legal basis for detention of Dublin III transferees. And it would be all the more surprising, we submit, if that were so in this context, because there was, as the Advocate General recognised in Al Chodor, no debate concerning Article 2N. You see that, I don't invite you to stand up if you want it, it's in the Advocate General's opinion at paragraph 65, on page 1674 of this same bundle behind tab 7. So no debate around Article 2N, if that had the effect of creating this fundamental sea change. And secondly, all the more surprising, because of the limits of competence ceded by member states through the treaties and the principle of subsidiarity that you saw referred to in recital 40. And that has the effect, we submit, that Dublin 3 must be interpreted in a way that means it's compliant with Article 5 of the EU Treaty, so it goes no further than necessary to achieve the purposes set out. That's the limit of EU competence. Member states, if you want to put it the other way, have not ceded general control of detention to the EU, quite the reverse, as that history demonstrates. So that's the second submission. The context is against it being legislation only. Thirdly, the wording and the EU legislation itself is powerfully against any such insistence on legislation only. You're very well aware of the basic structure of the Dublin 3 regulation. If you go back to tab 1, if you would, you'll recall, for present purposes, the basic structure which is set out in Article 28 on page 1260. And you see from that that sub 1 indicates that there is a preclusion against detention for the sole reason that the person concerned is subject to the procedures in the regulation. In other words, you can't detain them just because you're proposing to transfer. And then 2 applies, sub 2 of Article 28 applies, in the language you see there, to permit detention when there is firstly, a significant risk of absconding. I'll come back to that in 1 second. Secondly, the purpose is to secure the transfer procedures. Thirdly, the detention is proportional and other less coercive measures can't be applied effectively. And thirdly, if detention is justified on the basis of an individual assessment. All of those themes come out of that sub 2. But the critical thing for present purposes is the definition. And we note immediately that it isn't a definition of law, it's a definition of what a significant risk of absconding imports. So you go back in the regulation to Article 2, subparagraph N, on page 1251, in the left-hand column. So one sees that basic structure, and as I say, if the intention was through the reference to the word law as part of a definition of a wholly different concept of the risk of absconding, if the intention was to introduce this formal sea change, in other words, legislation only, it is, if I may respectfully say so, a mighty odd way of doing it. I should just note, and I'm not going to develop any submissions on this at all, but you will have seen from the Court of Appeal judgments, this is very much a parenthetical point, you will have seen from the Court of Appeal judgments there was quite a lot of consideration about what the Court of Appeal were being asked to do. And that fundamentally flowed from the true relationship between Article 28.1 and Article 28.2, and whether or not these rules, this debate, really applied only in circumstances where the sole basis for detention was to effect the transfer. I'm not going to go into that issue. It's a potentially complicated issue. The only reason I flag it is because when I got to the consequentials part of these submissions, it did occur to me that there might be a live issue still floating out there in relation to some of these cases as to whether or not they were really governed by these rules at all, which would lead to a possibility that they might win on all fronts and still lose, if that makes sense. But I noted from the Court of Appeal judgment that Mr. Swift, as he then was, had made a concession on behalf of the government. It was a concession / assumption, but it was nevertheless put in the Court of Appeal as a concession that these cases were within this body of rules, and I don't propose, therefore, to depart from that concession in these cases. So they're taken accurately or inaccurately on the facts to be covered by this body of rules. But so the point on Article 2N is if it was intended to introduce this formal sea change, it's a mighty odd way of doing it in a definition provision defining another concept. There's a separate and slightly broader point in relation to this. I said that the wording and the EU legislation sitting alongside 2M was powerful against it. And the slightly broader perspective, if one's looking at this as a scheme of EU legislation, is to have at least some regard to the reception directive, the recast reception directive, and that is in the second volume of authorities, behind tab 20, MS page 2079, if you're in the electronic. And
Sorry, could you give me that number again?
I'm so sorry, 2079.
Yeah, that's what I thought I heard. Yes, thank
I
you.
hope that's the right one.
Yeah.
Directive 2013-33 EU. So that's the recast reception directive. I make it absolutely clear at the beginning, as I said a minute ago, and you've seen from our case, we did not opt into this. But the reason for going here is because we're here dealing with an issue of EU legal interpretation. And this recast reception directive, for those who opted into it, not merely sits alongside Dublin III, but was effectively enacted or made on exactly the same day as Dublin III. So they sit as part of a composite legislative scheme, and it is to be assumed, therefore, that they are to be interpreted consistently and together for precisely that reason. But it's exactly the same day on which this is made as Dublin III. If you go in this directive to Article 8, 2084 in the electronic, you will see the basic structure of Article 8. It provides a series of specific grounds for detention. And so Dublin III, as it were, the Dublin III provisions that we've been looking at are a specific type of detention. But you'll see the basic structure of this recast reception directive. And you see the grounds that are specified in sub 3, right-hand column on page 2084, if you just cast an eye down at those. You will immediately pick up two things about that. The first is that under 3B, it refers to risk of absconding. You will see also in 3F that there is specific reference to Article 28. Yeah. But the reason for going to this provision, in particular, for the purpose of the debate that we are engaged in, is because you will see that all of those grounds as they're specified, including Article 28, but also including the risk of absconding in the rather different context of the sort of things that are being dealt with under this directive, you will see that the tailpiece of subparagraph 3 says the grounds for detention shall be laid down in national law. And that is one of a number of references in this recast reception directive to something very, very similar. There it says laid down in national law, but if you look forward into Article 9, which deals with the guarantees for detained applicants, you will see that in sub 3 of Article 9, halfway down the left-hand column on page 2085, there is a reference in the pre-penultimate line to define in national law. To this end, member states shall define in national law the period within which the judicial review and so on should take place. In sub 4 of the same article, if you just cast your eye down those and you get to the 4th line, procedures laid down in national law. If you look over to the right-hand column, still within the same article, on page 2085, and go to sub 10, the last of the sub-articles, procedures for access to legal assistance and representations shall be laid down in national law.
No definition of risk of absconding again.
No definition of risk of absconding in here. But you'll appreciate why I go to those provisions in the context of the issue that we have here, because the contrast, at least textually, is between the reference to law, in inverted commas, in our provision, Article 2N, and all the debate that came with that about French texts and loi versus droit and all of that. That's that bit. But here, you've got exactly the same thing being referred to. Indeed, you've got a reference to the very article. And the tailpiece of 8.3, the grounds for detention should be laid down in national law. So the submissions we make on the back of that, if I can summarise them in 4 or 5 short points. First, there is a close correlation between the concepts used in Article 28 and the concepts used in Directive 2013-33. Defined by law, in Dublin 3, for example, must mean the same thing as defined in or laid down in national law in the directive. Just before I go on, can I just invite you to keep that page open if you would, and could I just invite you to go back to Dublin 3? You'll see, just as the final piece of cross-referencing, as it were, Article 28.4, as regards detention conditions and guarantees applicable to persons detained in order to secure the transfer procedures to the member states responsible, Articles 9, 10, 11 of the directive, that's the recast reception directive, shall apply. So as it were, you've got a direct bounce from 28.4 and back into the recast reception directive. So close correlation, and they must mean the same thing. Secondly, national law, as we've seen it referred to repeatedly in the recast reception directive, means exactly that. There's no suggestion that when they use that concept, they're dealing with the identification of a particular type of national law or form of national law. This is subsidiarity in action. Thirdly, there could be no sense or coherent legislative policy served by introducing different legal bases for assessing absconding criteria for asylum seekers, focusing specifically on absconding, risk of absconding. No coherent legislative policy served by introducing different legal bases for assessing absconding for asylum seekers, depending upon whether they're a Dublin 3 transfer being considered, or depending upon whether or not they are within the directive which governs detention of all other categories. So they must mean the same thing when they're talking about law or national law in the context of absconding. Otherwise it becomes legislative policy incoherent. And that indeed seems to have been the view of the CJU in Al Chodor. So if you go back to tab 7, and you go to paragraph 28 in the court's judgment, on page 1685, you will see the beginning of para 28. This is the case with regard to Article 2N of Dublin 3. I'm in para 28 on 1685, which explicitly requires that objective criteria defining the existence of a risk of absconding be defined by law, quote. Since those criteria have been established neither by regulation nor in any other EU legal act, the elaboration of those criteria in the context of that regulation is a matter for national law. That's exactly consistent with those repeated references to laid down or defined in national law in the recast reception directive. And the importance, therefore, is that the objective criteria referred to in the definition in A2N are objective criteria set out in national law, and that they conform to the essentials of legality, with that concept of legality importing the same requirements whether you're under ECHR or EU law. So that's the third submission by reference to context. Fourthly, still on this debate around whether only legislation will do, the Advocate General in Al Chodor appears to have considered that legislation in the context of that case was necessary, i.e. that it needed to be formally legislation, but the CJU did not go there. And we say it can be inferred that they deliberately did not adopt that Advocate General formulation. And we submit for that purpose that if you have the Court of Appeal's judgments readily to hand, Lord Justice Sale's analysis of that issue, CJU deliberately not adopting the Advocate General formulation, is correct. That analysis is at paragraphs, particularly at paragraphs 96 on page 278 and 97. This was correct. In any event, still under this fourth submission, neither the Advocate General nor the CJU was considering, in effect, legally enforceable policy derived from the common law through jurisprudence, interpreted as necessary and enforced pursuant to public law principles by the courts. They were instead focused on legislation provided within a system which, if I may respectfully say so, looked fragmentary and also looked ex facie a little inconsistent in terms of the check system with the mandatory requirement that you shouldn't detain someone solely for the reason of transferring. The relevant check legislative provision was cast in mandatory form, must detain, and must detain when you're effecting transfer. Fifth and final submission on principle we make is that any such requirement, i.e. insistence on legislation only, would be to elevate form over substance. We're dealing here with the factors, the criteria, which should govern the approach to answering the question that there is a significant risk of absconding, and that in itself is a legal test. These are simply different formal routes for setting those out and controlling the exercise of overbroad discretion. And it's notable, as we point out in our case at paragraphs 38 and 5.38 and 5.39, that when the new legislative regime was introduced on the very day that Al Chodor was promulgated, effectively precisely the same objective criteria were listed as mandatory relevant considerations. It's also notable, it might be thought, something of a jury point, that until Al Chodor, no one in the immigration field had ever suggested that Chapter 55 was incompatible, or that people were unable to understand what criteria were applied, and courts and others were considering detention. So turning to the application of those principles here, the basic structure of domestic law is well known. There are legislative powers, as you know, in paragraph 16.2 of Schedule 2 of the Immigration Act 1971. They'd invite you to turn it up. It's in Bundle 2, Tab 10, page 1842, if you wish it. paragraph 1.3 of that same schedule, immigration officers shall act in accordance with instructions given to them by the Secretary of State. And you also have the power in section 62(1) of the Nationality, Immigration and Asylum Act of 2002, which is in bundle 2, tab 12, page 1948, again, if you want that, but very well-known powers. And then the powers are controlled first by Harjil Singh, summarised by Lord Dyson in I, a case called I. We've quoted it at paragraph 4.4. It's too well known to bear repetition. Aren't exhaustive, as Lord Dyson pointed out in the Lumba case, bundle 3, tab 24, at paragraph 30. So that leaves room for the public law duty to adhere to published policy. One of the things that he was specifically considering in the context of Harjil Singh. He says, yes, those are the basic principles under Harjil Singh, but they're not exhaustive, so they leave room for the public law duty to adhere to that published policy if it provides greater specificity. And it's been accepted, as I said earlier, throughout. Nouasley is the case, 75 to 77, bundle 4, tab 44, that those principles comply with EU law. And the policy to which Lord Dyson made reference in para 30 of Lumba is now, I think it has a different chapter number, but it is now the chapter we're considering, chapter 55 of the EIG. Again, for your reference, I don't know if I've given you this already, but for your reference, it's the policy itself is in the second tab of the first authorities bundle. And the key bits of it are critical paragraph is at page 1286. So bundle 1, tab 2 of the authorities. Paragraph is 55.3.1 at page 1286. And if one considers that policy and judges it by reference to the standard ECHR and it appears CJU approach to legality, it is accessible. It's published to the world. On the internet as part of the publications on the government website, which is the likely first port of call for individuals seeking to understand the government's approach. And it explains the whole decision-making process, and it's written in tolerably plain English. It has a basis in domestic law. If you still have it open and to hand, maybe one of the provisions, or the type of provision that my Lord Wilson was interested in. We'll certainly check earlier parts of it. But the basic effect you see summarised at least at 55.1.1 on page 1276. Do you see the paragraph right in the middle of the page? To be lawful. That point is repeated if you go forward to 55.1.4 on page 1280. Way down page 1280, it's effectively the same point repeated. Status was considered in Nadaraja, which if you keep that open if you would, and take up bundle 3 of the authorities behind tab 31. Lady Arden was one of the members of the Court of Appeal. 2439 is the first page on the electronic. For present purposes, I wanted paragraph 54. Particular, the statement that the relevance of Article 5 is that the domestic law must not provide for or permit detention for reasons that are arbitrary. Our domestic law comprehends both the provisions of Schedule 2 of the 1971 Act and the Secretary of State's published policy, which under the principles of public law is obliged to follow questions. That sentiment is echoed, and the importance of the policy was stressed by Lord Dyson in Lumber. If you put bundle 3 away, if you would, go back to bundle 1. Lumber is behind tab 5. It starts at 1498 in the electronic, and tab 5 of bundle 1. Paragraphs I wanted particularly for this purpose are paragraphs 26, page 1518. Passage I referred to earlier in paragraph 30, making the point that the Hardiel-Singh principles are not exhaustive. It's really that bit at the top of page 1520, but they are not exhaustive. That's the Hardiel-Singh principles. Can I invite you to read from there to the end of the paragraph? Paragraph 34 on page 1521, the rule of law calls for a transparent statement by the executive of the circumstances in which the broad statutory criteria will be exercised, just as arrest and surveillance powers need to be transparently identified through codes of practice, and immigration powers need to be transparently identified through the immigration rules, so too the immigration detention powers need to be transparently identified through formulated policy statements. That led to the conclusion of paragraph 66. That effectively it's between A and B, that a decision to detain that doesn't follow published policy undermined with the same legal consequences if there was no statutory power to detain at all.
I'm sorry, which paragraph was that?
That was, my Lord, I'm so sorry, that was paragraph 66. It's really the fourth line of that. There's a sentence or two beginning in the present context.
Thank you.
There is in principle no difference between A and B on page 1528. That basic approach was applied by the Supreme Court in the Kambadzi case behind tab 6 in the same file, starting electronic 1614. This was, of course, in the context of detention reviews. wanted the judgment of Lord Hope for present purposes, paragraph 40, page 1632, quite an important section, which I'd like the court to read, to remind yourselves of. Can we pick it up within paragraph 40 to try and keep it to a minimum? Within paragraph 40, you will see that 5 lines up from the bottom of paragraph 40 on page 1632, there's a sentence beginning, the requirements of the 1971 Act and Hardy-Singh principles are not the only applicable law. Does the court have that passage? Could I invite you to read to the end of paragraph 42? And then on in the judgment to paragraph 51, and again, if I may, can I invite you to read 51 and 52 on the same theme. Just to make it clear, within paragraph 51, just before you start reading, if you see 3 lines up from the bottom of page 1635, there's a reference to chapter 38 of the manual. That's effectively chapter 55. Right? And then if you go back to paragraph 18, which he refers to on the final line of that page, you will see 5, 6 lines up from the bottom of paragraph 18, the quotation taken from that, to be lawful detention must not only be based on one of the statutory powers in accord, but must also, do you see that? With the emphasis added. That was the passage I took you to, do you remember, in 55.1? So back, if you would, to 51 and 52. Could I invite you to read those paragraphs? Unlawfulness if you fail to comply. So we have, within Chapter 55, we submit a set of clear principles and objective criteria. They're foreseeable in their application, they're in clear, intelligible language, and it's an important aspect to bear in mind that if there is any issue as to the meaning or effect of the criteria, then that is an issue which is not for the Secretary of State to determine, subject to rationality. It is an objective question of interpretation, even though it's the Secretary of State's policy for the courts to determine. So the courts, determine meaning. If you wanted authority for that base proposition in this court, Mandalia, Bundle 4, I'm not going to invite you to turn it up, Bundle 4, tab 42, at paragraph 31. And the courts have indeed done so. We gave in our case at paragraph 4.7 the example of Owen, the Home Secretary, as a Supreme Court case in which exactly that was done. That's Bundle 4, tab 45, if you want it.
I suppose the point that might be made against you is at the end of 52, in the second last sentence, Lord Hope does qualify what he's saying to the extent that the the policies, if the policies are breached without good reason, continued detention is unlawful. So there is they're not binding come what may. There is that qualification there. But I suppose you might argue that if, for example, they were set out in legislation which contained similar qualification that in exceptional circumstances or something of the kind, they could be departed from, you would say...
Or if it simply was cast in terms of it being a mandatory set of considerations. Yeah. Yeah. Mandatory but not necessarily exhaustive. I'm going to come to that debate, and I know the court is very interested in this, I'm going to come very directly to whether or not the basic public law principle, which is you can depart from policy for good reason, is sufficient, as it were, to unravel all the wonders of the passages that I've been taking you to. But my respectful submission is that whatever else they indicate that a particularly strict approach is applied in principle by our courts, even if that exists at all, that ability to depart. A very, very strict approach is applied because of the context, because it is detention, and because it is so important that the detailed rules about detention are set out somewhere in public, in a general form. So you have 55.3.1, which is the key passage for present purposes. I know you will have considered them, you'll have seen them referred to in the Court of Appeal judgments. They've been oft-cited. They are, as I say, based on relevant considerations appearing from case law and that the courts have laid down in relation to the risk of absconding. They're all contained in one place, and I'll come back to whether their content is sufficient as issue 1B, if I may. But that's where they are. And so the first submission then, in relation to the application of the principled approach I outlined earlier, the first submission is that there is a clear policy identifying in a structured way the questions that bear on the power to detain conferred by statute, with all the accompanying case law on the meaning of the provisions and the effect, and all the ability of the courts to control that. Under domestic law, as we've seen from those passages, and as you see from the careful judgment of Lord Justice Sales in the Court of Appeal, they operate with legal force. They operate as a policy subject to public law principles, especially the principle or the doctrine of legitimate expectation, a concept just as well known in EU law as it is in our domestic law. There have been numerous cases in our domestic court, some of which my own friend Mr. Ford and myself have been in, called Drax Power in the Court of Appeal, saying that the domestic legal doctrine of legitimate expectation was exactly the same as the EU law doctrine of legitimate expectation, had the same foundation and effectively the same principled approach. We saw in the Court of Appeal judgments Lord Justice Sales citing for that purpose, i.e. that legitimate expectation was a base principle of EU law as well. He cited a textbook by Professor Tridimas in the judgment at paragraph 118. So legitimate expectation is one of the things that is reflected in the sort of statements of principle about policy that you've seen in the cases to which I've taken you, but it also reflects the basic public law principles of consistency of application of policy and the principle of good administration that Lord Justice Laws was very interested in cases such as Nadaraja. But they mean together that the executive has got to comply with the policy, applying the strict approach that we've seen, unless there is good reason not to do so in the individual case. And that you've got from the passages I took you to. You also have it, I can't remember whether it was referred to, I'm sure it will have been somewhere in the passages that you've just read, Lord Bingham in the Munjaz case, making that point effectively, paragraph 34. That's in bundle 4, tab 34, page 2541. I don't invite you to turn it up, it's a well-known passage from Lord Bingham. And it's also important to recognise that you can't ignore a matter which is potentially relevant to the individual case and the issue at hand. If you do so, you fail to take into account a relevant consideration. So that if, for example, one go back to the structure of the guidance, if one of the questions that you saw recited at 55.1.3, if one of those questions was potentially relevant to an individual case, but it was left out of account, and the decision maker said, well, I'm not going to pay any attention to that question, they would fail to take account of a relevant consideration. My respectful submission to come to it, my second submission is that legal control, that set of legal controls around this policy, is not unacceptably loose, if I can use that word, because of the unless good reason not to follow rider. It is to be noted at the outset that the absconding criteria, those questions, are stable. They've been arrived at over a number of years. They're derived from a repeated set of cases on what needs to be considered. They're stable. And of course, the usual paragraph 26 of Lumba principle has got to be read alongside Dublin 3 and its mandatory nature. So you couldn't decide to disapply or not consider potentially relevant objective criteria as they're set out. You simply couldn't do it. It wouldn't be lawful. And that, indeed, I think, I may respectfully not quite guess, but that, I think, is the point that Lord Justice Sales was making. If you go back to the Court of Appeal judgment at paragraph 117, couldn't have a good reason, he says, to introduce a new set of criteria where Article 28.2 applies, because that would not be permitted. But you'll bear in mind, in any event, I think it is worth making this point, in any event, there is sufficient control, we respectfully submit, in the structure of that policy, and with the wraparound of public law principled control established by the courts. There is sufficient control to satisfy the concept of law, a fortiori the concept of national law. Remember my point about the recast reception directive and the Dublin 3 regulation, all effectively meaning national law. But there is sufficient control to establish and satisfy the concept of legality, given the particular structure. And you'll bear in mind that the wording that paragraph 42 of Al Chodor used, if you remember that, the Luxembourg case, was that a framework was needed. And a framework was needed to enable that control of arbitrary executive decision-making to be sufficient.
You've really adopted Lord Justice Sales' paragraph 117 in your slightly notorious footnote 30, where you dispense with the tail end of the court's usual approach to policy. But I'm just beginning to wonder whether a policy can be binding, even though there is written into it that element of flexibility. In other words, I'm just beginning to wonder whether you needed to jettison in your footnote the binding unless good reason to the contrary part of our jurisprudence.
Well, my lord, I'm not sure I do. That's why I headed this second submission in any event. My first submission is that Lord Justice Sales is right in 117, but in any event, if I'm standing back and asking the question, is this sufficient? Even with the rider, it would be sufficient, I submit, because you need a framework. You don't need absolute, as it were. And the question is whether that provides sufficient protection to control against arbitrary executive decision-making. And that alternative submission, if alternative it truly is built around the reference to framework as a concept in paragraph 42 of Al Chodor, and reflects the fact that reasons to believe that a person may abscond have to be based on objective criteria. And also it's to be recognised, for the purpose of this submission, that the criteria don't necessarily lead to detention. You still have a discretion to detain, even if you satisfy the risk of absconding and so on. You've still got a discretion to detain, and that's got to be exercised on the basis of the circumstance of the individual case.
I mean, it might be said that there's a logical problem with Lord Justice Sales's approach, because the difficulty about relying on Article 28.2 to eliminate flexibility is that Article 28.2 refers to risk of absconding. The definition then brings in the concept of law for EU purposes. And Article 28.2 assumes that you're dealing with something that counts as law for EU purposes. And if flexibility, if the presence if the scope for flexibility deprives it of a character of law, then you don't get into Article 28.2 in the first place. It might be thought.
I see the force of that. And I think the reasoning perhaps was a little broader, which was simply to say, well, here are the requirements of EU law as now clarified. That means that you can't step outside the bounds of those things that you've set out. As long as you stay within those bounds, that is sufficient. It doesn't answer the legislation point, but it is nevertheless there. But as I say, there is a second position, and the second position is it's sufficient anyway, because actually you don't require.
Well, that's perhaps a more attractive
to go as far as that, because you've got sufficiency. You're permanently coming back to the yardstick. You're asking yourself the question: have we? Do it in ECHR terms, because they tend to analyse in accordance with the law rather more fully and separately to the CJEU, which is why that body of case law is perhaps slightly more developed on this front. Come back and ask that question: is there sufficient control against arbitrary executive action? And then say, well, what happens in relation to our guidance? Look at all our Supreme Court authority. You have to follow it. We leave the door slightly ajar, possibly for the purpose of this argument, that says there may be some limited scope. But then you say, well, what scope is there to ask another question, if you will? And it's incredibly limited.
Chapter 55 is actually a very detailed document. I mean, the point might be made that the technique of very detailed drafting of legislation to address every contingency is that's one point that might be made. Another is that one's rather wearing British spectacles. That's a very British way of drafting legislation. It's not how all countries draft their legislation.
My lord, it isn't, and I mean, to some extent that takes us back to the principle of subsidiarity, and and the respect for different forms and systems of law. But our system has always engaged that. And again, you remember back to all that Strasbourg case of Sunday Times and following, it's inevitable that legislation is going to be drafted at a tolerably high level of generality. So it is here, as Lady Hale pointed out. But underneath that, you have various mechanisms of control. Some of them directly court-driven, some of them, as it were, policy, so the initial instigation comes from the Secretary of State, but based on case law, but surrounded all the while, in our system of law, with a bunch of legally enforceable rules, which are called public law. That's how it works. So the only real question is whether unless good reason not to, is in some way, shape or form, even if it allows a little move, as it were, from them, is that sufficient to undermine its lawfulness? We respectfully submit not. Because any such move, if you think about it, however narrow, any such move would have to be controlled by the principles of public law, including in particular the principle that you can only take into account a relevant consideration and you can't take into account an irrelevant consideration. So there is legal control even in relation to whatever narrow movement one might perceive. I'm going to take you very briefly to Omar, if only to show you where it is. But this was the Court of Appeal rejecting a challenge to the new regulations that were passed in the light of Al-Chodor. It's in Bundle 5, tab 52.
Page?
Oh, I'm so sorry, 3050, sorry. And there's a helpful analysis of Lord Justice Davis giving the judgment with which Lord Justices Ryder and Higginbottom agreed, that begins at paragraph 37 on page 3060. Effectively, that little section runs to the end of paragraph 46.
So in a word or two, what was the basis of the challenge to the
I
regulations?
think the basis of the challenge to the regulations was were that they were still just a list of relevant considerations, and that they didn't set out with sufficient precision the objective criteria, and were therefore they therefore didn't conform, even though they were formally legislation, they didn't conform in substance to the requirements of Al-Chodor. See that from, just to pick up the point, 38, Dublin 3 regulation has indeed left it to each member state to formulate objective criteria for the reasons for belief in the risk of absconding. Reject Mr. Fordham's suggested approach just above the letter C. At all events, on his approach, all member states should be expected to have the same, or at least substantially the same objective criteria in the national law of each of them. Second point is that the arguments advocated on behalf of the claimant seem almost counterintuitive from the point of view of Dublin 3 individuals. One would have thought that the almost tick-box approach to an exhaustive list of objective criteria, which is advocated, might tell against rather than in favour of their true interests and not be conducive to fairness. Certainly they don't easily fit with the stipulation in 2N. Reasons to believe that there is a risk of absconding must be looked at by reference to the individual case, as also confirmed in 28.2. Third, linked to that, 2N, drafted by reference to reasons to believe there is a risk of absconding. Force of Mr. Payne's objection, the claimant's approach would tend against an individual assessment and evaluation, such a basis of belief and would tend to equate with that more the fulfilment of any objective criteria of the existence of significant risk. They don't get any assistance from Al Chodor because it was on the legislation point. Then at 42, I see it, paragraph 42 of the decision on Chodor as, if anything, actually against the claimant's argument. Not only does it confirm the individual discretion available to member states in relation to the existence of a risk of absconding, it also confirms that the discretion is to be exercised within the framework of certain predetermined limits. The word framework is revealing. It accords entirely with the word on 2M, which requires the reasons to believe are based on objective criteria defined by law. Then he rejects in 43 the idea that it's simply no more than a non-exhaustive list of relevancies. 46, to pick it up at the bottom of page 3061, crucial further aspect of the overall approach called for. In fact, it was not the case that if objective criteria some rule and health must be detained. To the contrary, Article 28 makes clear that the assessment of the exercise precedent to a decision to detain, and so on. In the interest of the asylum seeker, not only require a weighing of the relevant criteria, but also do not in any way cut down, taking into account all residual matters relating to the fairness and proportionality of actual detention. See that rather more flexible approach, as it were, to the Chodor decision. Recall that our policy at chapter 55.1.3 referred to all relevant factors being needed to be taken into account. Well, there's nothing objectionable in that, following that reasoning. It's a jolly good thing, it might be thought, because you need to consider against the framework the individual circumstances of the particular case that you're considering. Otherwise, you can't work out whether there's a proper risk of absconding or whether or not, even if there is, someone should be detained. There may be jolly good reasons not to, even if there is a risk of absconding. So that flexibility does not deprive the policy of the force of law for the purpose of EU law or ECHR law. And bear in mind as well when considering that if, so that's factors outside as it were, but if one of the questions that is in fact listed was not taken into account, but would nevertheless have been relevant or potentially relevant to the individual case, that would be a straightforward public law error and would be controlled because you'd have failed to ask a relevant question as specified in the guidance. You wouldn't perhaps even need the policy for that purpose. You just simply would have failed to take into account a relevant consideration. But for good measure, you would not have followed the policy and you would not have a good reason for not following the policy. That's why the wraparound of public law is so important, and fully understanding how the usual principles that relate to the following of policy with the good reason rider, how they are attenuated in our context and how they are controlled. So the alternative submissions are either A, Lord Justice Sales 117 was right, or B, even if that isn't so, there is sufficient control in the specified questions, in the fact that policy is controlled by public law in all of those ways, there is sufficient control for the purpose of satisfaction of the principle of legality. That's the second submission in relation to the application of the principled approach in our context. And I've spent a little time on it because I know it's a subject of concern that was raised, so I hope that's acceptable. The third submission is that this context and this legal structure i.e. the one I've just described and we've just been discussing, is distinct from the context and facts in Chodor. In Chodor, as far as one can tell, there was no collation of the controls and the factors of the kind that we see set out in the policy. There's no indication that there was the sort of principal control by the courts through the operation of public law that we have here. There was simply a loose collection, it appears, of fragmentary judgments of the local courts, with the possibility existing of a whole series of other criteria being simply developed by administrative practice, possibly with, possibly without, a chop being put upon that by the local courts. And bear in mind, when you go back to Chodor, the nature of the basic legislative provision, which frankly on its face looked as though it positively obliged the Czech state to do the very thing that Article 28.1 said you should not do, which is to detain simply because you were transferring. And so there were, unsurprisingly, fundamental problems with foreseeability and with the basic nature and adequacy of the control of executive discretion, leaving open the possibility of arbitrary decisions and therefore a violation of Strasbourg or whether you went to Luxembourg. And those were all features, amongst other things, of the Advocate General's opinion that we've summarised in our case at 5.7 to 5.9, various features of Czech law and the Czech system. Fourthly, the requirement for there to be external direction of the discretion. My submission in relation to that is that the role of the UK court in public law provides that external direction and control. The court's role here, unlike in the Czech Republic, is not simply, as it were, endorsing practice promulgated by the state, but it is to provide, through legal principle, control to hold the executive to its clearly set out statement of policy in the manner that I've described. And that is sufficient to conform to any requirement that there should be external direction of the discretion. True it is that the policy is promulgated in the first instance, to go back to my Lady the President's point, promulgated in the first instance by the Secretary of State, but we note it was based on case law and it is controlled by public law. We therefore do respectfully agree on this part of the submissions as well with the judgment of Lord Justice Sales between paragraphs 121 and 123. So I simply invite you to note for the time being. That's all I wanted to say about legislation only. I wanted to move, if I may, to the content of Chapter 55. And so my second main submission is that the contents of Chapter 55 are also sufficient to comply with EU law. That's the Court of Appeal's Issue 1B at paragraph 115 of Lord Justice Sales's judgment. That's the second of those issues that I'm now turning to. And it's to be noted at the outset that the regulation I don't think this does suffer even arguably from the logical flaw my Lord Reid was putting to me, but at the outset that the regulation is directly applicable as a regulation, as part of our domestic law. So there's no need, for example, to have the preclusion in Article 28.1 against detaining solely because you just want to transfer. There's no need to have that set out. What is needed is the setting out of objective criteria in a way that legally controls what factors will govern the risk of absconding. That's what's required. And the essential battleground or disagreement between the members of the court below were that the majority considered at this stage, they didn't offer a view on the first issue, but on this, in other words, legislation only as an issue, but on this one, their reasoning is essentially between 170 and 174, and they conclude that it wasn't a framework of certain predetermined limits, as they put it. And Lord Justice Sales disagreed, in particular between 124 and 129 in his judgment, and it is respectfully his reason that we support. We submit that it does not undermine the policy from an EU perspective that some of the questions that you saw in 55.1.3 do not relate to the risk of absconding. And we also submit that there is no need under EU law for a freestanding form containing only the criteria or questions relating to risk of absconding. As Lord Justice Sells, if you have his judgment to hand, as he pointed out at paragraph 125, and if you have the questions open at the same time, that's not too many files all at once, 1286 of the relevant questions behind tab 2 in Authorities Bundle 1. As Lord Justice Sells points out at 125, the first 7 of those do. So down to the bottom of 1286. And you see if you go on at page 1289 in the policy, that there's a title at the bottom of that page, Risk of Absconding. So paragraph 5.3.2.5, spanning 1289 and 1290. They essentially, those paragraphs, those references essentially replicate the questions that we saw earlier and expand by reference to a couple of examples. And so Lord Justice Sales' first conclusion, and we respectfully submit that it's a good one, is that if that has stood alone, in other words, if bullet points 1 to 7, if you number them down, there are 7 on page 1286, if they'd stood alone, that would satisfy Article 2N on any view. The majority criticised the fact that only one of them, that's the second of the bullets, refers expressly to absconding, but our respectful response to that is that express reference is nothing to the point for present purposes. Expressly to refer if the other questions do plainly go to the risk of absconding, as they do. And indeed the majority seem to accept that the first 7 of those do indeed go to the risk of absconding. That also, if you recall, was one of the key conclusions reached by the Court of Appeal in the OMA challenge to the virtually identically phrased criteria that were set out in the regulations when they were passed on the day that Chodor came out. So the first 7 of them do. So the question which is raised then is whether the existence of a mixed one, that's the 8th, which Lord Justice Sells concluded was mixed, and I think the Court of Appeal disagreed with that. So it might be relevant to risk of absconding, might be relevant to other things. Does the inclusion of that mixed one, or questions not relating to the risk of absconding, i.e. 9, 10, and 11, undermine lawfulness? And my short submission is that Lord Justice Sells's reasoning is impeccable on that point. There's no requirement for an exclusive list dealing only with the risk of absconding, or for a standalone document in Article 28 or in the definition in Article 2N. So there's nothing in the language of the provisions that we're dealing with that says it's got to deal exclusively with it rather than being compendious, so that, for example, if we'd signed up to the Recast Reception Directive, it dealt with risk of absconding and the other matters that you could detain on the basis of. There's no such requirement stated by the CJU or even the Advocate General in Chodor. And as Lord Justice Sells pointed out at 128 of the judgment, it would have been very, very easy indeed to dispose of the case on this simple ground if there was such a requirement in Chodor. So there's no support in the text, there's no support in the case law of the CJU, and there's no requirement in principle, we respectfully submit, for that. And that is because what is being aimed at is satisfaction of the basic principles that govern legality under the EU system or the ECHR system. Legal certainty, predictability, prevention of arbitrary detention can all be met without any such formal need to split out and to have it only dealing with those matters and not having other aspects covered. The objective criteria exist, and they are for this purpose adequate for the purpose. That's the assumption for this purpose. They're good enough for this purpose. The question is whether mixing them up with other questions undermines their lawfulness. And back to public law, there is no possibility of taking into account another question not relevant to the risk of absconding, because by doing so, you would plainly breach domestic public law. You would be taking into account an irrelevant consideration. Again, I characterise it as something of a jury point, but I note that it was a point that was made by Lord Justice Sells as well in 129. No one has ever suggested that anyone was misled by or didn't understand which of these questions went to the risk of absconding and which did not. Indeed, no one had ever said that there was any remote difficulty with this until Chodor appeared. And so we respectfully disagree with the thrust of the concern expressed by the majority at 173 in the judgment, where they appear to be concerned that Chapter 55 was, as they put it, intended to cover all immigration detainees and not merely those subject to Dublin III. Well, that is true, but that's a point about form and standalone. And it doesn't detract from the existence of the legal controls by objective criteria in cases in which there is a risk of absconding in issue, in other words, Dublin III, because the questions are there, 1 to 7, and the possibility also of 8. And the control is there because if you asked question 10 or 11 or some other question that wasn't relevant to the risk of absconding, public law would deem that to be and find that to be unlawful.
Are the people who decide whether to detain somebody also given, in addition to these instructions, some manual or other guidance which tells them what the legal criteria are for detention in particular circumstances? Are they actually told what the question is under Dublin III? Now, of course, it's there in the law. I accept that. But when one's thinking about life on the ground, with a person making the decision as to whether or not somebody should be detained, do they have handily available? Remember, if this is a Dublin 3 case, you are only allowed to detain if there's a risk of absconding. And this is what it means. So don't take into account things that are irrelevant to that.
I don't think I can say that on the evidence before the courts below and this court, there was any evidence going to that specific question. I am very well aware, and you're very well aware of my answer, but I'm very well aware that the Court of Appeal majority were concerned by the very point my lady just put to me.
Yes, well, that's why I'm...
Do they actually know what systems they have to apply, what law they have to apply? But my answer, I'm afraid, is that if they, that the law is there, if the regulation is there, and just as the domestic legislation is there, the regulation is a part of domestic law, and if they fail to conform to it, if they reach a decision which doesn't do that which Dublin 3 says you have to do, if they seek to detain on the basis of something other than the risk of absconding, they act unlawfully.
But in the usual way, and I obviously can't say about this case, there would be a form, a detailed form, which the officer would have to complete, would there not be?
I think they would normally, but I just don't know what, I don't think there was...
Any evidence about this in particular, but in the normal case?
Operating on a hypothetical basis, but I just don't know whether there is something like that or there isn't.
In order for them to record the decision, they would then have to go through the requirements in the form.
Yeah. If I've missed something, someone will tell me, but I don't know whether there's anything...
And there would have to be regular reviews, would there not?
Certainly, it isn't.
If there was a decision to it.
I would, of course, accept that it would be a great deal better if all of those legal provisions were in one place or were within the form, so they had to go around and do it in that way. But my basic answer, even on the assumption that they don't know, or that there isn't any clear evidence that they know, is that we're here on a debate about legal control.
We do have some of these forms in Appendix 3.
Yes, I think some of them are referred to in the Court of Appeal's judgment at 179, for example.
Yeah.
We don't think it refers to Dublin.
Because at that stage we haven't made the decision.
Yeah, with a shorter journal, we'll put together a little clip of
That would be helpful.
what we haven't got. But as I say, I certainly accept that it would be a great deal better if all of the things were easily in one place. But the fact of the matter is that here we're dealing with legal control, and the answer that I give is that the regulation is part of domestic law. And that is, in short, the answer to quite a lot of the concerns that the Court of Appeal majority were worrying about. One of them was that there was no reference to Dublin 3 itself. And my answer is that there doesn't need to be. It's part of English law without more. And a mere reference to Dublin 3 doesn't have anything to do with the objective criteria being set out adequately so as to control the risk of absconding. And the same answer is given in relation to the fact that Article 28 cases can only involve detention if there is a risk of absconding of that kind. Again, Article 28 is part of the law.
But surely the individual has a right to know what considerations have been operative in his case and be able to check that they are within Dublin 3.
My lady, yes, and that's the significance, I submit, of the factors. Those are the objective criteria. You set out there the questions, which are, in, I emphasise, identical form, effectively, to those that were set out in the 2017 regulations. That is a sufficient, clear indication of the objective criteria against which any such detention would fall to be done.
Thank you.
Similarly, in relation to proportionality, all of that is, I respectfully submit, built in both through Dublin 3 but also through in the guidance there is, or in the policy there are various references to that sort of issue. Continuing need to keep it under review at the back end of 55.3.1. 1287. You'll remember under the paragraph headed risk of absconding 55.3.2.5 on page 1290, penultimate sentence there, the greater the risk of absconding, the more likely it is that detention will continue to be appropriate. Consider, as the guidance makes entirely clear, and so does Dublin 3, the individual circumstances of each case. What you're after is a framework that sets out, in effect, the legal criteria against which that risk of absconding falls to be judged. But my submission is that that is more than sufficiently dealt with in the policy. Ladies and my lords, that's what I wanted to say before coming to the issue of damages, which I've got to deal with after the short adjournment. I think I've got another hour, if you can face it after lunch. And so I hope we're in good shape.
You have another hour, and you have another 2 minutes, but I don't think you need them.
Well, it may be convenient to break now, just as I'm going on to a whole new topic.
Absolutely. Thank you. Well, we'll look forward to hearing from you again at 2 o'clock.